Dharwad benchmark. What's next? Number 1. We'll call it municipal code.
Take that. MFA is filed by whom? There is this.
MFA not that has to be dealing.
It is asking to first dealing MFA number 21127 of 2012. The present CRP is filed. Agreed by the order is passed in. Where is the order?
Order passed in appellate RA number.
Page number order. In RA number 1 of 2009, dated 15th of April 2011, whereby
P and SC number 12/2008, which is at date November.
whereby the appeal filed by the wife, the appeal filed by the petitioner herein is dismissed by confirming the judgment and decree passed in PNSC number 12 of 2006 dated 2012-2009, wherein whereby the court has observed that the petitioner has failed to prove that she is a legally wedded wife of the she is a legally wedded wife. That she has failed to prove that she is a legally wedded wife of the respondent.
Wife of Shivaji Andalkar, who is deceased.
Shivaji Angarkar, who is deceased. Agreed thereby, the present revision is filed. During the pendency of this revision, this court on the it is submitted that on 12/12/2024 that the matter is settled and the sought time for filing the compromise memo. On 16/12/2024, the parties were present before the court and it is stated that they wanted to compromise the matter. And on that day, it is brought to the notice of the court that one of the LRs of the respondent were not brought on record, but they are part of the compromise. Considering this court has permitted the petitioner to file the petition and also observed that to file the complete petition and also observed that the presence of the parties is not necessary as they are already present before the court and submitted about the compromise. And compromise. Now thereafter, the complete petition is filed. And the wakalat is also filed by the respondent and the consequential amendment is also carried out. As per the compromise memo, where is that? This matter, the earlier matter, Bangalore matter, in chambers. In chambers at 5:30.
1612.
Not serial number, what is the name? 2 in chambers at 5:30.
advocate for India, Mangal.
कुछ क्यों नहीं ऐसा इसमें था ना उससे? हाँ, नहीं निकालेंगे ना उसमें से।
Compromise, first one.
हाँ। What is this? Now what they accepting these kind of people? Just extract the compromise reached us. Extract the entire compromise in the light of the compromise entered into between the parties. The nothing survives for consideration. In the light of the compromise, the CRP is disposed of. And the order dated so and so is set aside. And the order dated so and so confirmed of the trial court, which is confirmed with the appellate court in RA number so and so, is set aside. The compromise memo shall be annexed to the order. Yes.
Directed to issue succession certificate.
No, all that not necessary now.
Not necessary. No,
In the light of this compromise, everything will work out.
Yes.
Yes, next.
Seal number 2. Document restoration.
Which case?
Seal number 2.
Non-compliance of office objections.
This is 1.1. No. Yes, a week's time. It's not week's time. By 15th of January, the office objections shall be complied with, or else default order. Yes, next.
Seal number 3.
Huh? No, what appearance?
Seal number 3.
Non-compliance of office
Non-compliance of
objections. The office objections shall be complied with by 15th of.
Sorry, I'm appearing on behalf of regarding the office objections. The age of the petitioner.
Whatever it is, comply with the office objections, then only we look into it.
My lord, it is correct age only, and the court fee has been paid.
What is correct date?
My
Why
lord,
will
the
they?
office objection has been based on age of the petitioner and respondent. Has to be clarified. But the age of the petitioner and respondent.
How to be clarified? Clarified as per the cost rate in the before the trial court.
Please, my lord, even in the order sheet presented, my lord, it is about 22 years old age. If my lord is pleased to see annexed hearing, my lord. Page number 9 in the order sheet, my lord, regarding the age. The MC has been.
Court fee provision to be clarified.
My lord, regarding the court fee, it has been informed that the court fee provision is corrected state.
Why should you do it? Do it.
My lord, so the password I do it in the.
No password. If the office objections are clear, if the office objections are complied with this matter tomorrow.
Tomorrow.
Yes. Next.
Tomorrow.
Seal number 9. Seal number 4.
One of 24 is filed. If you recall the order dated 2011, my lord.
Why you should be recalled?
My lord, fresh steps had to be taken for R2C, my lord. When we instructed the party to get the
So
correct
please tell
address.
the court what is the whole purpose of passing an order, a default order.
My lord.
At least the advocate client will realize that it has to be done. No, there is no fun of passing an order, don't doing it again, filing it a recalling petition in every case. Waste of court's time.
My lord, the petitioner, my lord, he gave us the address. He furnished the correct address of R2C a day later, my lords. I filed the PF on, I paid the PF on 29th, my lords. Order was passed on 2011.
So what I'm telling you is, it doesn't matter, like, court can pass order. It's all waste of judicial time. Judicial time, for them to do, for listing, everything is waste of time.
Apologies, madam. We are based on it.
Please come, please come. IA number 1 of 24 is filed, seeking to recall the order dated 2011-2024. It is stated that where is this 2011 order? On 2011-2024, this court granted a week's time to do the needful. If the needful is not done within the time granted, the petition stands dismissed without reference to the court. We submitted that the petition is ready to the client has given the correct address a day later, and they couldn't comply, do the needful within the time granted by the court. As such, the petition is dismissed. Hence, they have come up with this petition to recall. Now it is submitted that they pay the process, and also the correct address is furnished. Considering the same, the order dated 2011-2024 is recalled, and the petition is restored to file. This starts the service of notice. Yes, sir.
Still number 5. Still party. And then party.
Mike, I'm not able to hear you. There is a 2011 order. Why they will write? What are the reasons for this? It is not on one occasion. On several occasions, and in spite of giving an opportunity by posting the matter for dismissal, and which you know that day the matter will be dismissed. In spite of that, if you don't turn up, then what is the conclusion the court has to draw? Huh? Yes. No, this petition is of the year 2023. On 8/11/2024, when the matter came up before this court, there was no representation, while the learned counsel, the respondent, was present, and therefore the matter was directed to be listed on 14/11/2024 under the caption dismissal. Today also there is no representation. So what are the good reasons for both the days? No, because you have any difficulty, you have colleagues in the court, somebody would request if you tell them. The present IA number so and so is filed to recall the order dated so and so. Order dated 14 November 2024, where this court had dismissed the matter for default and observed that on 8/11/2024, when the matter was listed, there was no representation, and the matter was directed to be listed on 14/11/2024 under caption dismissal. And today also there is no representation. As such, the matter is dismissed for default, and counsel admitting to the petitioner submits that on those 2 days she was not feeling well. As such, she could not represent the matter before the court. The matter is dismissed for non-prosecution. It is submitted that the absence on the day is neither willful nor wanton, but for the reasons stated. Considering the same, IA number so and so.
3 of 24.
3 of 24 is allowed by recalling the order dated so and so, and the revision is restored to file. Place this matter on 31st of January. Yes, next.
Still number 6. Legal party.
Hello.
181 days with any notice. Notice.
So the statement, in the present case, they filed a recovery petition, then they served on proper address.
No.
Please.
Yesterday, you were telling the court
Please.
that the address, both the addresses are not one in the same.
But he is a resident of Bagapur district. The recovery petition is served on his native address. They showed the wrong address in the petition, the alternative service they have served. Well, the permanent
Take that.
address is served. Please. Get 1,000 rupees maintenance and then fix it.
How will it be served like this?
No, your no,
But something is given like that.
my lord, just what?
No. Basura Jagdish, what is it? Yadgiri.
Jagdish. But again,
Bagapur district.
That's it. With that, you will get this communication.
No,
And something that
it's
is.
a court notice served on that one.
No, that's what I'm saying.
Please.
If something is sent like this, it is served on you, and that address, is it your case that you don't reside in that?
He is residing there. His native place, the address shown on the cover is native address, but they have not shown that address in the petition alone.
No. Is it your case that you do know you were never residing in this place?
No, my lord, he is not at all never resided. It's only thing is that his friend's house at Bangalore, but not his house.
It is served. Your friend's house.
No, he is also not residing there right now over there. It's a rental house of his friend, one of his friend. But even today, his friend also not residing in that address. But well, the wife, as a wife, he knows the permanent address also, but he has not chosen to show the address in the petition. They shown in the Bangalore address only. But
Then
he is
how
not at all his address.
how come a different address is shown here?
No, they are not at all shown. In alternative address, they have given that address. But in the petition, they are not mentioned. They mentioned Bangalore address only.
I'm not able to understand one thing.
Yes.
No, even in this petition also, this is what is shown.
Yes.
And where from this has come, that notice you have received?
Yes. Well, it's court notice. Then only we come to.
How much is the amount granted?
8,000.
What is your income?
No, my lord, he is unemployed. He is in the joint family property, only 2 acres of land is carrying.
Then how much without blanket order will not be granted, whatever is the reason?
Well, I'll.
To pay how much?
3,000.
The agreed with the order dated 28th February 2024, whereby the court had granted an amount of rupees 8,000 to the wife. The husband is before this court with a delay of 181 days in filing the petition. Generally, this court will not entertain will not entertain the stay petition in a delay matters unless and until the notice is served on the respondent. It is submitted with an answer for the petitioner that the address that is furnished by them before the court, by the wife before the court, is not the place where the husband is residing. He submits that when the recovery proceedings were initiated, he came to know about the order that is passed, and he furnishes the cover that is received by him from the court, where the address is shown, where a different address is shown. Basing on this, the council submits that without intentionally, they have suppressed the fact that he is not residing in the set address and furnished the wrong address. The next part, the court had granted 8,000. In spite of all these facts, the husband has a responsibility to take care of the wife. That way of the matter, they shall receive all further proceedings on the condition that the petitioner shall deposit an amount of rupees 4,000. Arrears also at 4,000. Bharati. Arrears at 4,000 from the date of petition. Within shall be deposited, shall deposit the same within 8 weeks from the date of receipt of the copy of the order. Either any of the non-compliant, the same default order. Registry is directed to issue notice to the respondents. Yes, ma'am.
sure.
Yes.
Seal number 7. Ask.
The petitioner, Your Lordship. The husband is a petitioner serving, Your Lordship. He was placed ex parte. The reason being is that, Your Lordship, the respondent wife had instituted a criminal case, Your Lordship. He was in the custody in the year, till the year 2022, and this honorable court, by granting bail, Your Lordship, had imposed the condition that he will not enter the city of Hubli, Your Lordship. This was well within the knowledge of the wife, Your Lordship.
Is she appearing in this for the respondent or what?
Next matter, Your Lordship. So in that case, Your Lordship, he was not in a position to enter the city of Hubli, Your Lordship.
Yesterday, I said, if you're ready to pay that amount,
This is a different matter, Your Lordship.
this is not the one.
This is not the one.
Let's see the order.
Annexure A, Your Lordship. And if he's been placed ex parte, Your Lordship, there are 4 petitioners, there were 4 defendants in the husband, Your Lordship. A total of 25,000 has been awarded as a maintenance.
Against respondent and so on. So direct the respondent to pay 10,000 per month to the one, 5,000 per month each to respondents, children 2 to 4.
Children, Your Lordship. There are 3 children, Your Lordship. So in total, 25,000.
What is your salary?
I'm not working, I'm on contractual basis, Your Lordship.
When is this order passed?
This order was passed in the year 2023, Your Lordship.
16th October 2023. When did you come to know about this?
Only when the execution proceedings were initiated, Your Lordship. May I request Your Lordship to kindly peruse the annexure C, Your Lordship.
Oh, there is a delay. We'll order notice in this.
Your Lordship, there is a reason for the delay, Your Lordship. For a moment, Your Lordship. I was not supposed to enter the city of Hubli, Your Lordship. That is the bail condition.
You don't enter. You can file wakalat.
But Your
Your
Lordship,
advocate
that
can
was
give
not. So I was placed ex parte, Your Lordship. The wife was not knowing that I'm not in Hubli, but then she also she's given the
No.
address, Your Lordship.
Wherever in the you are even if you are in the US also,
Yes.
you can engage an advocate.
But it was not within
And
my knowledge. Not within my knowledge.
why notice would have been served on you?
No, Your Lordship, because I was not within the city, Your Lordship. It is unclear.
Like
Your
is that
It is unclear, Your Lordship, for the reason that I'm absent in the city of Hubli, Your Lordship. For
for
that,
how many years?
I'm not in Hubli since year 2022, Your Lordship. From the day the bail has been granted, Your Lordship, I've been barred from entering Hubli, Your Lordship.
Forever.
Only on the date of appearance of criminal case, Your Lordship. So whichever date is being given to me, I'm supposed to enter that to the court premises and then have to get out of the.
Where is that order?
Annexure C, Your Lordship, page number 61. Your Lordship. Condition number 4, Your Lordship.
Page number?
61, Your Lordship. Page number 61, condition 4, Your Lordship. The petitioner shall not enter in the Hubli city except appearance before the court till the completion of trial, Your Lordship. With this condition, Your Lordship, I am not supposed to enter the Hubli. And deliberately the address of Hubli, or the address of the.
Why in that address, except you, nobody else
Nobody
is
is there, Your Lordship. That
You
is
have
the-
no family.
The reason is that, Your Lordship.
You have no family.
The husband and wife, they are residing in the same house, Your Lordship. That can be seen from the cost item, Your Lordship. May I kindly request Your Lordship to kindly peruse the page number 11.
This order is passed on 29 June 2022.
23, Your Lordship.
2022.
The
That is
bail
the
order.
bail order.
Yes, Your Lordship.
Even that is subsistent even till now.
It is subsistent because the trial is proceeding, Your Lordship. In fact, Your Lordship, the petitioner is ready to deposit any amount that has been indicated by this honorable court, Your Lordship. Because they are now proceeding in the execution proceedings, Your Lordship. They are actually residing in the house of the petitioner.
So now, even in the execution proceedings also, nothing can be done to you because you cannot be taken to Hubli.
That is the difficulty is with the petitioner, Your Lordship. That is the difficulty.
No, that's what I'm saying. Now, if the execution petition is filed, what are the consequences of it?
That has come to the knowledge only after.
No, what will happen? Nothing will happen because there is already an order that you should not enter. So they will not take you to the. They won't.
Now the problem is
They,
that
even the court cannot, send.
If that order is executed, Your Lordship is violating the bail condition, Your Lordship.
They won't execute. Already there is another order. So
There is
it will be-
conflicting
in
orders.
that, in that view, nothing will happen. So we'll order notice.
Your Lordship, there may be stay, Your Lordship, subject to certain conditions by this honorable court, Your Lordship.
No, you're seeking stay for some reason, isn't it?
There
That
is-
you may be like, some, the drastic steps you are anticipating. But in this, nothing will happen. You can't, hopefully they
There is
can't.
a threat of being taken into custody by the criminal
How will they
court.
take?
Because, Your Lordship, there will be reason that it is entering the city of Hubli, Your Lordship. That is violating the condition.
No, you will not enter. Why will you enter?
Your Lordship, eitherwise there is a conflicting order on me, Your Lordship. So,
No, because of that order, you have not contested the maintenance matter.
Maintenance matter.
No, because of that order only, they cannot do anything to you. So you wait till the wife enters appearance.
Your Lordship, there will be right of arrest, Your Lordship. So subject to any condition imposed by
15,000 and arrears at 8.
Arrears have already paid 1 lakh, Your Lordship. As on today, there is.
Deducting that, now court has granted 25,000.
Yes, sir.
Pay 15,000 and the arrears within 8 weeks on that condition stay.
Yes, Your Lordship. I'll abide by the conditions.
It is submitted that. That the court had granted an amount of rupees 15,000 to the wife,
10,000.
10,000 to the wife, and
5,000.
5,000 each to the 3 children. Altogether, an amount of rupees 25,000 is granted as maintenance. It is submitted that petitioner is accused in crime number.
SC number, Your Lordship.
In SC number, in crime number 57 of 2019, for the offences under section 498A, 323, 324, 326, 307, and 504, dealt with section 149 of the IPC. This court on 29th, a coordinate bench of this court on 29th June 2022 has granted bail, and while granting bail, the condition imposed is the petitioner shall not tamper the prosecution witnesses directly or indirectly, and he shall not enter in Hubli city except appearance before the court till completion of trial. It is a case of the petitioner that as the trial is still in progress, he is not permitted to enter Hubli city, and the address that is furnished in the miscellaneous petition is the address where they were, both the wife and husband were residing together. The notice to the respondent is returned, notice to the petitioner returned with the postal endorsement unclaimed, and which was held to be a deed service, and the order is passed. It is submitted that no opportunity is given to him, that he didn't had an opportunity to contest the case. And then how did you receive these notices?
When this person has come for the trial, Your Lordship, then he came to know, then he has taken the certified copies and then he has submitted.
Who told you when you came to trial?
It was informed to him, Your Lordship, that there is an attachment of property.
When he attended the case, the pending criminal case, when he came to know about this, it is also submitted that he has already paid an amount of rupees 1 lakh. Considering all these aspects, though there is a delay in filing this petition, considering the facts and circumstances and balancing the interest of both the parties, the petitioner, there shall be stay of all further proceedings on the condition that petitioner shall pay an amount of rupees 15,000 by 5th of every succeeding month, and the arrears at 15,000, deducting the amounts that are already paid, you shall deposit the same within 8 weeks from the date of receipt of the copy of the order. If any of the default, if the petitioner fails to comply with any of the conditions above, the stay granted by this court stands vacated automatically without further reference to the court. Next, on such deposit, the wife, the respondent guardian, is at liberty to withdraw the same. Registry is directed to issue notice.
But okay.
Number 8 is Karnataka completely irrelevant.
Your Lordship, this case is with respect to the Visitation Rights, Your Lordship. Your Lordship is 12,000 euros.
Uh,
And this before this honorable court, he has paid 10,000 euros. So as of today, he has only paid 22,000 euros.
and what is this calculation coming from?
Total 36,000 he has paid, Your Worship.
But
Today,
very assertively, you were like,
today he will pay, Your Worship, 10,000. In every month he will clear it.
those are all not legal aspects, sir. Factual aspects,
this is
you
not
should find out from the
economic
client. You just can't assertively say, as if you have paid to them.
Yes, Your Worship.
So how much you paid?
He
According
paid
to him,
36,000, Your Worship.
36,000, and according to you it is 20?
23. Yes, yes, sir. There is previously which he had.
So 36,000.
36, yes, sir.
So that 1,04,000 would be the outstanding.
Yes.
No, you today is paying 10,000.
10,000.
Okay, let him pay. Then what would be remaining is 94,000. And then that 94,000, when would you pay?
Every 2 weeks, every 2 weeks he will
How
pay.
much? So every 2 weeks?
He will pay 7,000 and clear all the errors. In 14 days he will clear, pay
No.
for food.
Before this, you said your client wants to clear everything in 3
3
months.
months, he will clear it.
Every 2 weeks, you pay 7,000. Will you clear it in 3 months?
No, Your Worship, but
I was saying that's why 7,000 on every week. That is 28,000.
please,
Every weekend you'll have the
Yes.
registration. Every weekend 7,000.
please, please.
Tell the court what you can do. Not like simply don't 7,000 every time you go. That's how you will complete it. So, as per the earlier order, on 30/11/2024, 7/12/2024, on all these days he has exercised the registration.
Please.
You went all the days.
Not all the days.
1, 2, 3, 4, 5, 6. 6 days it is. You exercised. You couldn't go. Then how the registration was? He was speaking to you. What he says?
He didn't talk on last day. Your Worship.
He did? Never.
He didn't talk in last day. He
Ah.
didn't visitate because of that reason. He didn't talk to his child on last day, and he was saying that every time on visiting rights, mediation center, she used to bring the petitioner used to bring her whole family, and you hand over the mobile to the child, and he will be sitting on mobile, and every time Your Worship, in
What
between
I,
the
what,
family members
what
used
I
to call
told
him.
you, what I told you on the last occasion, what I told you on the last occasion, the visitation will go on like how you want, but you should speak to your father. If you don't speak to your father, then you cannot ask the court to do how you want it to be.
No, I didn't hold it for that.
Don't do it. You are supposed to talk to him. Your problem was he was not being good with you. That's why I asked you to meet before in an advocate's office. And that doesn't mean that you just do whatever you want to do. Then what will happen? Then what you were asking on the last occasion, that you shouldn't be, you don't want to go to his house, you don't like that, and you want to be in the place where along with your mother. So considering that this order is passed, when the matter comes up next time, I want to hear from your father that you're speaking to him and you're being good with him.
No, I didn't. That day my mother didn't got phone.
Forget about what your mother got the phone or not. What I'm telling you is from the next, whatever is the next date, be good to him, talk to him. Forget about what are all has happened all these days. Okay? Please come. This court on 28/11/2024 had permitted the father to exercise the registration on 30/11/2024, 7/12/2024, 14/12/2024 at the mediation center in Gokak between 2 p.m. to 4 p.m. On 1/12/2024, 8/12/2024, 5/12/2024. On Sunday, the father was permitted to exercise the registration between 10 a.m. and 12 p.m. at the office of Sri S.P. Hireman, advocate at Gokak. In case if there is any holiday for the mediation center at Gokak, the father was permitted to have the visitation at the office of the advocate even on a Saturday also. What about him? He wants to, because the boy's vacation is going on. If he wants to visit, we will increase the visitation. Not about 12. It is now, he is on vacation now.
Please.
He wants it, it was only fixed on a Saturday
Please.
and Sunday.
Please.
If you want, we can add one more day also.
Please.
Ask him.
Wednesday, Friday. Friday.
Yes. It's holidays instead of Sunday. Let's have it let it be on Wednesday, Thursday. He's working.
No,
So Wednesday, Thursday, Friday would be fine. So
Fine.
that the court will be there.
fine.
Wednesday, Thursday, Friday. On till the vacation.
Please.
Till the vacations will go on. After that again on the same Saturday, Sunday. On Wednesday, Thursday, Friday, till when the school reopens for him. Till 2nd of January, the father can exercise the visitation at mediation center at Gokak between 2 p.m. to 4 p.m. Whenever it is a holiday for the mediation or the court, he can exercise the visitation at the advocate's office, that is Sri S.B. Hireman, advocate 5th Cross, Vivekananda Nagar, Gokak. After the school reopens, this clause number 3, after the school reopens, again the visitation would be between on Saturday and Sunday. Saturday is 2 p.m. to 4 p.m. and Sunday it is 10 a.m. to 12 p.m. On those days also, when it's on a Saturday, if the court is working, it would be in the court or else in the advocate's office. And on Sunday, the visitation would be at the advocate's office. Next point. It is submitted that so far an amount of rupees 36,000 is paid by the father. The father who is present before the court submits that whenever he exercises the visitation on every week, he'll be paying an amount of rupees 7,000, and in that manner, he'll be clearing the outstanding. This exercise shall go on till March. This exercise shall go on till 20th March. Let's this matter on 21st. Huh?
There is an early to vacation stay, but I not forgot.
Let it. Yes.
Grateful.
For dismissal, still number 9.
Yes.
Yes.
Day before yesterday, sir.
Huh.
CP
So like I've already indicated to you what is going to happen.
My special suggestion is honorable for the respondent is having the well political background. It is very threatened because the kindly there is the LC petition.
It is like this. Now, if somebody says there is threat, there should be something else. Just saying in the affidavit is not sufficient. You must have given a complaint to the police. How will the court understand? It is not on an oral assertion saying that I have threat. Everybody will say that.
They have made a serious allegation against me.
Might be. What were you doing is the question. What were you doing when already the trial has commenced? That's the whole thing, because we can't have a different yardsticks in this. For everybody, for everyone, this is once the trial commences, we will not. Already the matrimonial matters are heavy pendency is there. Judicial officer who has spent a lot of time on that. And who is the client who is not vigilant in time? No, we can't reverse that now.
My particular section for that, it's a very difficult to come the sincerely to bully.
Why did you, then how are you doing it till now? You did it. That's why the matter is coming to the evidence stage. Please come. Agreed with the orders passed. Yeah. The present petition is filed seeking transfer of MC number 455 of 2022, pending on the file of the first edition in Principal Family Court Hubli, with the Principal Family Court at Gadag, where criminal miscellaneous number 10 of 2023 is pending adjudication. The facts of the case are: the marriage was solemnized on 27/11/2020 at Dharwad. In view of the differences between the parties, the respondent hearing has filed MC number 455 of 2022 seeking divorce before the first additional family court at Hubli. The wife, the petitioner herein, had filed criminal miscellaneous under 125 CRPC seeking maintenance, and she has also filed a petition under the Protection of Women from the Domestic Violence Act on the file of the second additional civil judge in JMFC court at Gadag. It is a case of the wife that the respondent is a political, it is stated that there is threat to her life. It's a politically influential family, and the distance between both the places is 80 kilometers, 85 kilometers, and it's difficult for the wife to travel. As such, a case needs to be transferred to Gadag, where two cases are pending. Learned counsel appearing for the respondent submits that already that is disposed of.
Criminal measures.
Learned counsel submits that the criminal miscellaneous is already disposed of, and it is submitted that now the matter is at the stage of
Cross-examination of PW1.
cross-examination of PW1. It is a contention of the learned counsel for the respondent that at this stage the petition cannot be transferred. Next part. Having heard the counsel on either side, there is a material on record. The contentions, the reasons that are stated for transferring the matter is: one, that the distance is 35 kilometers. Second, there is a threat to the wife and the family of the respondent. The family is an influential political family. Now, the family, in this backdrop, the contention of the learned counsel of the submission of the learned counsel of the respondent that already the trial has commenced and it is coming up for the PW1 cross-examination assumes more significance. The petitioner had kept quiet till the evidence has started. Once the trial has started and the court has spent a considerable amount of time on the case, it is not appropriate on the part of this court to transfer the matter from one court to the other court. Though it is stated that there is threat to the life, except an assertion in the affidavit in the petition, no complaint is given to the police. If such a threat is there to the petitioner, and it can always be brought to the notice of the court. If required, appropriate orders will be passed by the family court, giving any kind of protection that is required whenever she attends the court. Even on that ground also, there is no requirement to transfer this petition. In that view of the matter, this court finds no accordingly dismissed. Yes, ma'am.
Admission matter still number 10. Question sign section.
This was listed last week. The question was that unmarried daughters cannot pay maintenance 125%.
You got the judgment? read it? Have seen this?
Yes. Sir.
Please come. Agreed with the orders passed with criminal miscellaneous number 279 of 2018 dated 1st April 2022. The wife is before this court. She had filed a petition under section 125 CRPC seeking monthly maintenance of rupees 15,000 per month to herself and to over petitions 1, 3 and 4.
Therefore, one is why.
One is seeking a maintenance of an amount of rupees 15,000 to herself and two daughters.
Three daughters.
But you know what is the distinction? Two, she made it Pavitra.
For 10,000.
There are three daughters. For the daughter, for daughters, that is the petitioners 3 and 4. The court she sought for herself and the two daughters she sought for 50,000, and for one daughter who is the younger one, she sought for 10,000 as maintenance. The court by order refused. Which para is that?
Is it page number 31, operator portion?
Page number?
31.
There is no that. How many matters are there before the court? Only one?
Two petitions. One is filed by wife, the other by husband.
Oh, husband is questioning which order?
Husband is questioning the same order, my lord.
No, like,
in respect of maintenance to 3 daughters, 8,000 per head was awarded, my lord. In respect of all the 3 daughters. That he is challenging, my lord, saying that 2 daughters are already eligible, they have completed the education.
But that's your contention,
That is my contention.
not the court's observation.
Only
So
in
according
respect
to you, because the major daughters are not
Yes.
entitled for maintenance, is your contention?
No.
2 daughters.
2 daughters, and so far as respondent number 4 is concerned, my lord, that is the youngest daughter. In respect of her, I can undertake to give maintenance, my lord, until she completes her education. That is my only contention that since these 2 daughters are.
And you filed for?
Well, no maintenance was awarded to wife for the reason that she has delayed to join the company of husband.
She has not shown
My
sufficient
contention
cause.
is that, my lords, she is residing in the marital home itself. It is a home built by husband only. Now, after retirement, he has not joined. So, his intention was not.
He actually wants to join my lords. Once when he attempted to join my lords, they threatened with his life, my lords. They all came together as a family and threatened him. So that's the reason, because of that, he is staying at some place.
Unfortunately, she is in matrimonial home.
Yeah.
So you
And
cannot say
in
that she
fact,
is not,
my lord,
she is
he
not
raised
joining
the
in the
loan.
matrimonial home.
In fact, he raised the loan we paid.
What is his salary?
He was working, my lords.
He's retired
when
now.
he was working, it was 58,000 my lords. Since he is retired now, it is
How
only
much now is paying?
34,000.
16,000.
As of now, yes, my lord.
As of now,
24,000.
12,000 he is paying now because there was
He
stay
paid
out of.
maintenance.
No. The order of the court is?
Order is 8,000 per head. That is to all of them, it is in all 24,000. That he was paying. But since now interim maintenance is 12,000, he is paying that.
Then
But my contention is. as of now-
will not, as far as the wife is concerned, will dismiss his petition. And that 8,000 will come to the daughters.
But-
How much he'll pay?
Please.
My lords, but even in respect of those 2 daughters, my lords, they are earning, my lords.
Where is the
Only to exploit that.
No.
They have
If you have,
completed their education.
no. If you want to place anything on record, we'll see that they are earning.
She is actually working in a company, my lords. As far as the records are concerned, I can produce those records, obtain and produce those records. But my simple contention is, my lords, since I have always already given them all the educational expenses, I have looked up after them until they completed their education. But But now when they are capable of earning, my lords, even when to exploit me, they are saying that I want maintenance even
No,
now.
for example, you are, when there are no strained relations and all of you are together, want to take care of your daughter till she is capable of,
We are ready to take, actually, my lords, he approached them and told them, you can stay with me, I am ready to look after them. But they don't even want to maintain any kind of relationship with the father, my lords. They only want money, my lords.
Contrarily, surprisingly, is he who doesn't want to join because our contention and defense taken before London Royal Court is also that. Because 3 daughters were born, he was reluctant and he was expecting a boy.
no, is it what
This
she
is
says
great,
is
great
correct?
allegation.
That you want only his money, but you don't want to see
No,
him.
my lord, no, my lord. Today also
Even
we are,
when he has
in fact,
undergone a major surgery, my lords, recently, they didn't even go to visit him, my lords. They didn't see how he's doing, what is his condition. They want money, but they don't want any kind of relationship with the father, my lords. How can any person, who only they are dependent on money can be ready to give money, my lords?
my lord, this day also we are ready to accept it. We are not denying him. He is not ready to come back. Apart from all those maintenance
That's because
what
he
is
was
being
pregnant.
avoided.
Is it correct that you did not visit him when he underwent the surgery?
No,
Not even once,
we were
my
never
lords. No
informed
effort was
and we
made.
do not even know where he resides now because he
You
was
get the
working.
money, right, every month?
No, my lords, where he appears before trial court, but
No, you get the money every month.
Please.
So there is some responsibility to
Please,
know
madam.
the person who is sending money is where he is.
please, my lord, we do not deny that. Even we want
They
him
are not even aware
join.
where he is, my lords.
We also want the family to be united itself, but he is not coming forward. And in fact, one more submission, if I
Now
may
he cannot
keep
even
it
walk,
and
my lords.
Lords, the matter was referred to Lok Adalat. Wife has appeared, but he did not come before Lok Adalat.
That's because he had undergone the surgery, my lords. That's what the hip replacement.
How is he now?
He is not able to walk, my lords. He is still bedridden. But maybe he can. But as of now, his condition is not that he can walk and appear.
No, what we'll do is, about these contentions, we'll list this matter on 15th. Can he appear before the mediation center on 9th? Is he in the
I'll seek
position
instruction, my lords. I'm not aware.
tomorrow?
Yes.
Come on.
It's tomorrow. Okay.
Case number 11. Santosh Kumar ji, you would
Please, appear on the husband in this matter. Today, not an instruction that perhaps today, the divorce petition which has been filed by the wife, today is process for judgment. And already with respect to the maintenance, perhaps we have already paid 1 lakh and that has been ruled out before the trial.
This is matter after vacation.
Please, wait.
At the request of both the parties on January 15th.
Please, wait.
Yes, 15, 14,
Please.
14 holiday.
14.
14 holiday.
No, I'm saying next month.
Next month, sorry. Case number 14. A Pata. A Pata.
Yes.
We have exchanged our affidavits. It is my contention without any reasonable cause, she left the matrimonial house. And now she is demanding her payment. Even in the last occasion before the same dishonorable court, it was offered that for one-time settlement or he is ready to take settlement. But both the matters she is not ready. She wanted a monthly matter. And
How much he is ready to settle?
Plus, we have offered for 5 lakhs. The court itself has suggested for 5 lakhs.
5?
5 lakhs.
What is the age of the petitioner?
Age of the petition is 38 years.
No children?
No. Only for 4 to 5 months she decided with the husband. One more thing.
How much is granted with the court?
It's a 13,000. And after paying 50% of the years, we have obtained the interim order. And since from the day of.
So for one-time settlement, what is that she's coming forward?
No, they are not come forward, my God.
They say
Because
5 lakhs.
petitioner, because.
They say 5 lakhs.
The wife demanding at least 25,000 because he's working as accountant superintendent, my lord. And
Why she doesn't want to join him?
She's ready to join, but he has not made any separation because.
He also says, why both of you ready? That's what
Not
according.
one small thing. The Jamaat people also tried as this regard because they have taken to her to his rented house and have not provided food and clothes and medicines, etc. and given maximum torture to her. Then she left the house of her husband and she was going to her parents' house. Now she is residing parents' house. There are so many.
No, MC is not filed.
What?
MC is not filed.
No.
Yes, we have tried for restitution of political rights.
Restitution of political rights, she has said.
It is allowed.
It's allowed.
It is allowed.
She has not complied.
No, yes, it is allowed. Then she went to the husband's house and he studied in Dharwad and stayed in the house of the petitioner. And he has not provided anything. Then the father of the petitioner, his own wife, they have taken her and maintained the wife. They have given maximum torture. Mental,
Go before the
physical,
mediation. This is both the parties are directly appeared for the mediation center
and
on 21st of January. Yes, next.
one small petition. Because she is unable, because she has not made any mental.
No, the court has granted.
No.
How much? How much? 10,000.
The last appeal, they have.
Not.
It is submitted with the lead counsel petition
Not
that,
withdrawn.
that as per the order passed for this court, that every month depositing an amount of rupees 10,000 and 10,000. The respondents are at liberty to withdraw the same.
Seal number 50. This is Jnanaya Swami. Allappa respondent.
After vacation. Why? On the last occasion, I said I'll dismiss it.
We applied.
Yes. Next. Yes. 16.
Seal number 60. Those behind. Yes,
Vice petition. Vice petition. Maintenance is granted from the restoration of, from the date of restoration.
That's what yesterday's matter.
Yes.
Yes, sir.
What are your instructions?
Your Lordship is ready to pay 4,000 per month, Your Lordship, from 2012, Your Lordship. Because the order is from 2012, Your Lordship, and reasonable time may be granted to him to clear the
This
arrears.
is, will consider that request of 4,000 because 7,000, 12 to 24, how much it would be? So, just calculate from, I'll take up this matter with all the figures, we'll pass an order tomorrow.
Yes, yes.
Whatever that's paid, that has to be paid, what are the dates and all you prepare a note.
I'll
Basing
file a
on,
memo.
basing on that, we'll pass an order. And the time frame also, as from your client, we'll look at it. If it is fine, or else accordingly court will fix extend it with her before.
Yes, yes, yes.
Yes, tomorrow.
Much more.
Yes, next.
Seal number 70. Mallikarjuna Swami Hiraman.
Yes.
Respond number 1 is a basic period in Your Lordship, rather than that. The respond number 1 is the basic.
Yes, yes.
Not in this past, under section 34 of Constitution Act. This will not I have limited rights, I know that.
We'll
Only thing I'll try to persuade my lords, Lord. May I request my lord, a cost title. Respond number 8.
Which cost title of the
My
trial
lord,
court or
in this
this court?
revision cost title. Here, respond number 8.
Yes.
This Chhatrapati Shivaji Education Society, my lord, is the borrower. Now bank is, my lord, before this, my lord, court. The bank, my lord, has initiated securitization, my lord, against the, my lord, Mahadev Deshmukh, who is the father of this plaintiff. The borrower is society, my lord, the Chhatrapati Society, which is running a medical college in Maini, Maharashtra. The loan was, my lord, obtained for the purpose of, my lord, equipments for the medical college. Meanwhile, what had happened, Lord? After borrowing the money, there was a dispute among the, my lord, management. Mahadev Deshmukh already resigned, he is no more in there. While, my lord, obtaining the loan, he has not given this, my lord, his individual property, joint family properties as a, lord, surety. There are other properties also. The college is situated at Maini. Now the management is taken over by, my lord, some other persons. There is a dispute. These persons are completely, my lord, out of it. Now the bank
is not proceeding against the Malad college, which has sufficient income. It is a medical college.
That we cannot.
That is there, Malad. Only one thing, Malad, I can. Now only, Malad, this person has been made scapegoat. Now he is no more in the management. Now the problem, Malad, he will lose the land also. He has not control over the college also. And the bank has
So
already.
why would anybody mortgage their personal properties for?
He was managing, he was the chairman at that
No,
time.
managing means it's not his college is not his own. He is like
Yes, Malad, he should not have, Malad, that mistake has been done. Now the Malad,
Except,
now
the court
the
has sympathy for him.
amount is, Malad, it is 30 crores. Now it has, Malad, sold to, Malad, 30 crores. Even if they, Malad, even the auction
No,
sale.
what you can do is, for all this, you can go before because surfacer proceedings are already initiated. You can go before the tribunal with all this, but not a suit.
That is section 17, Malad, that is the law. Malad, I know, Malad, that is why, Malad, one more, Malad, opportunity, only I may not be, Malad, whether it can be settled, Malad. I can, Malad, try it, Malad, bank, there.
Then we'll do one
and
thing.
Notice they are
No, we'll do one thing. Now, instead of passing a final order, I'll stay these proceedings.
Please, sir.
Stay the proceedings in the suit. And would you like to, any supplement?
They did not come forward. Several opportunities were given.
No, he's saying
Malad,
that.
here, Malad, again,
They are buying time for on every occasion. It is not that the bank wants his settled. They are not interested in their properties. Ultimately, bank wants his money back. They took time in the petition. They obtained the interim order.
No, we'll do one thing. I'll adjourn this matter to tomorrow. Let him get instructions.
Malad, in this.
The same order I'll pass tomorrow.
Malad, in this, Malad, respond number 8. Let the notice to go to society also. They are party.
I show.
The notice.
I show you to your also. It's virtually a family society. I don't want to make comment on that family.
What
No,
you
they are
do
not. Management
is,
of
considering your submission, I'll adjourn this matter to tomorrow. Get instructions. We'll pass the same order tomorrow. The order is that CRP is going to be allowed, PET is going to be rejected. Yes.
Okay.
Tomorrow. Yes.
Malad, today, Malad, because they can only, Malad, their only chance is, Malad, to pursue it. Because
better is let them go before the tribunal and ask for what they want.
Let there be interim order, Malad. Till next week. Let there be interim order, Malad. Let there be interim order, Malad, next till January.
On all the 3 days.
Malad, even this fate is my fate is same, Malad. Let there be, Malad, interim order.
We'll pass a final order. Here. The present revision is filed agreed with the orders passed in.
Malad, one liberty may be reserved. If our property is, Malad, family property is, Malad, mortgaged, and it is sold off in auction, liberty, Malad, to be reserved to this, Malad, respondent number 1, plaintiff. In case it succeeds, he establishes that, Malad, this property loan is obtained by for the benefit of the bank, then he can recover. That, Malad.
How can in the rejection of plate all these orders can be passed?
But that property, Malad, he loses that property.
That can't be, because it's beyond the
Yes.
you're asking some relief which this court can't grant. Agreed with the orders passed in I number 11, invoice number 3535 of 2019 dated. What is this great order this day, March 2023?
They are, in fact, first page doesn't better here. Let me get it at the last page.
No, what is this date, March 2023?
Page 20, probably
23/5/2023. The defendant is before this court. The respondent herein had filed a suit. Where is the plaintiff?
Page 33.
Filed a suit seeking partition and 1/6 share in the suit scheduled properties, and also to declare that the order passed by the Deputy Commissioner Belgaum dated 2/2/2018 is illegal and not binding on the plaintiff. It is the case of the plaintiff that the suit scheduled property is a joint family property. The father of the plaintiff had borrowed the loan for the better working of the seventh respondent funded institution from the HDFC Bank and a healthcare infra finance healthcare equipment loan. And the bank has, how much is the loan amount granted? Has granted the loan,
The outstanding as of today is more than 31 crores.
has granted the loan. It is stated that the HDFC Bank, as the account has become IPA, has filed an application dated 2/2/2018 to the District Magistrate Belgaum for the recovery of the loan amount. It is stated that the District Magistrate, without following the due procedure of law, has delegated the powers to the Assistant Commissioner Chikodi. In turn, the Assistant Commissioner directed the powers to delegated the powers to Tehsildar Chikodi, and he in turn directed the Revenue Inspector to hold the Mahajan and appoint a receiver to take possession of the medical equipment of the properties belonging to Chhatrapati Shivaji Education Society. It is the case of the plaintiff that that property is a joint family property. Father cannot mortgage the same. And he also refers to the disputes in the said college among the members. It is stated that the defendant number 1 is acting against interest of the institution and illegally high-handedly beheld the bag without the consent or knowledge of the plaintiff, trying to alienate the suit scheduled properties to third persons in collusion with the Deputy Commissioner and the HDFC Bank by taking undue advantage of the mutation of his name to the advantage of his name. As such, has come up with the present suit. In that, the bank has filed an application under Order 7 to 11. It is a specific case of the bank that, in view of the bar under the Surface Act, the civil court has no jurisdiction to entertain the suit. It is stated that already they have initiated the proceedings on the Surface Act, and the aggrieved party has to go before the same, and they cannot maintain the suit. By order impugned, the trial court had dismissed the application, holding that the plaintiff has filed a suit stating that the properties are the joint family properties. And though that aspect, whether the property is a joint family property, whether the plaintiff has a share in the said property, has to be decided exclusively by a civil court. As such, the suit before the trial court, before the civil court is maintainable, and there is no bar of jurisdiction, and the suit can be entertained, and accordingly dismiss the application. Next one, when counsel appearing for the appellant bank submits that the court had felt that the order that's passed by the court is contrary to law, is contrary to the settled legal position and the provisions of the Surface Act. It is submitted that only to defraud the interest of the bank, the plaintiff has come up with the present suit. He submits that when the Surface Act proceedings are initiated, if the petition is aggrieved by the initiation of those proceedings, as per section, which is the section Affected party.
17.
As per section 17 of the Surface Act, yeah, being an affected party, he can approach the court. And when his grievance can be answered as per the provisions of the Surface Act, the suit is not maintainable. Next para. It submits that, not same para, it submits that court without considering all these aspects had dismissed IA filed by them under Order 7, Rule 11. Next para. Counsel appearing for the respondent, plaintiff submits that the father cannot mortgage the property, which is a joint family property, and the son has every right to seek partition. And the relief of partition can be granted only by a civil court, and the comprehensive suit filed by him seeking partition. It is submitted that now a property which is worth crores of rupees is going to be sold for a meager amount. Is it what you said?
My lord, this property, my lord, the property, principal borrower is the, my lord, society.
He submits that though there are other properties to the society, the bank is not proceeding against the said properties, and in collusion with the college, with the educational society, they are proceeding against the properties of the guarantor, that is the father of the plaintiff. It is submitted that it is a collusive action, and the petitioner, the respondent plaintiff, is going to be affected by the same. It is submitted that the bank ought to have proceeded against the society, which is a principal borrower. Further, the court has rightly considered the content, the IA that's filed by the bank, and rightly dismissed the application. It submits that there are no grounds to interfere with the well-considered order passed by the court. Next one. Having heard the counsels on either side, there is some material on record. The undisputed facts are the 8th respondent society has obtained the loan from the bank, and the 8th respondent society has approached your 9th defendant.
Yes.
The petitioner bank.
Defendant number 8.
Huh?
Defendant number 8.
The defendant, that your college is?
Defendant number 7.
The defendant number 7 college had availed the loan by mortgaging the suit scheduled properties. They have failed to repay the loan, and as the account has become an NPA, they have initiated the proceedings under the Surface Act. Now, the father of the plaintiff, who was managing the society at that point of time, has mortgaged these properties to the bank. Now it is the case that the father has also nothing to do with the same, with the affairs of the college, and it's a joint family property. This is a case where the bar of there is a clear bar of the bar of the jurisdiction of the civil court is clearly attractive. In view of Section 17 of the Surface Act, the petitioner, being an effective, the plaintiff is a party who is affected by any of the proceedings that are initiated by the bank, is always at liberty to approach the tribunal. Here, this is not the case where any fraud or anything alleged against the bank which needs to be decided by a civil court in the light of the law laid down in Matter Capital Criminal. In that view of the matter, this court is of the considered opinion that the suit is not maintainable before the. With regard, what is this? With the section 17?
Oh, sir, 17 is the only remedy. Even if it is not a party to the.
That's what, in view of that 17.
Yes.
In view of section, and in view of section 34, civil court had no jurisdiction, and the only remedy available to the plaintiff is to approach the statutory tribunal under 17, and no suit is maintainable before the civil court. In that view of the matter, the order imputed so is set aside, and consequently, I number so and so is allowed, and the plaintiff is rejected. Accordingly, this is allowed. Next.
Number 18.
Yes.
Start there.
Does not survive does not survive
For consideration. Why?
Suppose the MFA is filing before the division bench, the petitioner and respondent
They compromise. Compromise. You appear for the respondent.
I'm filing this memo.
It's not your senior. Respondent.
Submission ಮಾಡಿ ಪ್ರಶಾಂತ್ ಅಸ್ಕಾರ್ದೇವ್
He has muted it.
ಮ್ಯೂಟ್ ಆಗಿದೆ ಪ್ರಶಾಂತ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ
Please, I appeal for the respondent, my lords.
It is submitted.
Please.
It is submitted. It is submitted with both the councils that, in the light of the order passed in MFA number 103923 of 2023, dated 3rd December 2024, where the parties have compromised and an order is passed. For compromise and the order is passed. In that view of the matter, nothing survives for consideration this petition, and according to the RPF is closed.
Please.
Next.
Disclose.
Yes, next.
Number 20.
20.
Party Deepak S. Kulkarni.
Or she says,
She is ready to go, but you will writing that you take care of her property.
he should give in writing,
Yes.
or the court should give in writing.
No, he is giving.
Then what is the difficulty to give in writing that he will take care of her? If it gives her happiness, something in writing saying that he'll take care of her, let him give. We'll post this matter tomorrow. Where do they stay? In here only, or they're coming from outside? Huh? Then we'll do one thing. I'll pass out this matter. What she's asking, that undertaking, whatever it is that you file, and she'll join him. 2:30 in the chambers. Yes.
Number 21. Chetan Munwadi.
Yes.
Vijay Bhatt.
Krishna, but till today there was a arrears of 60,000. Yes, cleared it for us. I'm filing a memo to that effect.
Today we filed the area.
Hmm.
Today he has paid.
It is submitted that as per the order passed by this court, by this, the entire arrears are cleared. You have withdrawn?
Through phone pay minutes I have transferred.
As the entire arrears are cleared, this is matter after vacation on 20th of January.
Interim order granted.
Interim order earlier granted is extended till then. Yes, next. Yes.
Number 20. Anil Parekh. Montes Raymond.
I see password man. Council is end up in court on 3. Lord sir.
It has to wait, or orders needs to be passed, or after? Huh?
In chambers, Lord, this was both people are petitioner and respondent. Directly, Lord, they are not now found up, Lord, house for rent.
Oh, this is the one. We'll have it tomorrow, because password is not possible.
Yes.
Tomorrow? Yes, tomorrow.
20th.
Yes, 23.
Number 23. Petition Karnataka.
125 proceedings, madam. I could have given 8,000 rupees.
Interim order is there.
No, interim order. This is what I seeking, madam. We have.
Where is the counsel for the respondent?
Was appeared last time. In earlier madam, record proceedings, we have paid 35,000.
What is the amount granted?
8,000.
Uh,
And earlier, while interim maintenance, during the pendency, we have paid more than 35 to 40,000, 40,000. And after that, legal person, we have paid 35,000. So out of they are claiming 2,90,000 down. So deducting that amount, we are ready to pay 1 lakh rupees in 4 days.
You can pass on it tomorrow, members.
Inform me. Yes. No representation for the respondent or the counsel of the petitioner. This is marked tomorrow. Yes, 24.
Seal number 24. Petitioner Sirama.
After vacation at the request on 3rd of February. Next, 25.
Seal number 25. Sachitana Forward. Deputy Head.
5.1, and for appellant. Filed vacating stay application. Need to file objection. First time it has come.
After vacation. This is matter on 4th of February. Yes.
4th February. I'll just take 1 minute of my lords. In MFA, my lords, I'm a tenderer, my lords. I'm a successful bidder. KSITC has given this wood property, my lords, to build a complex, my lords. It is a temporary structure. My lords, I have built the structure up to 80% of the proposed height. My lord, it is constructed by putting pillars and by adjoining beams, my lords. My lord, their prayer, my lords, is to declare the tender process as illegal. The prayer itself is not maintainable by virtue of section 21 of the KPPP Act. My lords, they have filed a suit for representative suit, wherein all the 3 plaintiffs, they are having independent interest. Plaintiff number 2 is running a commercial, he is running a lodge about 100 meters from the suit property. He comes and files this, my lords, the present suit, seeking to declare that the tender process is illegal. I mean, take 1
Has
minute.
he participated in the tender?
He has not participated. They have not participated in the tender process at all.
Not
They are
regarding-
complete strangers.
My only suit is for injunction.
My lord,
On the ground that the proposed construction would cause nuisance to the public.
my lord,
Order on roulette application came to be allowed, challenging that he has preferred this CRP. And my application for temporary injunction, ex parte order was granted in my favor.
What is the main suit?
Injunction, suit for injunction.
suit for injunction by declaring that
Without obtaining permission, he made a construction.
My lord,
My application, even though point number 1, prima facie case was held in my favor, my application for a temporary injunction came to be dismissed. In appeal, this honorable court has granted ex parte temporary injunction order in my favor. Now he has filed vacating stay application, my lord. Allowed to file detailed objection. 3 days ago, he has served copy to me.
my lords, my only submission would be them. My lord, for a minute their prayer might be seen, my lords. For a minute their prayer, my lords. CRP, my lords. Page number 42, my lords.
Page number?
Page number 42, my lords.
CRP notice is not yet issued.
My lord, in MFA also they have produced the plaint. They have the plaint copy with them. I'm not reading anything apart from plaint, my lords.
Yes.
The prayer, my lords, page number 42, a decree for permanent injunction be passed restraining the defendants and their men for constructing any building, lodging or from using any portion of the suit property for commercial purpose by declaring that the tender called by the defendant number 1 to let out the suit properties for commercial purpose in favor of defendant number 2 and its procedure is illegal, arbitrary and not tenable. My lord, section 21 of the Karnataka Transparency Public bars any civil suit, my lords. How would a representative...
1 minute.
Please.
So please come to the play, the cost item.
Please, my lords.
Who is this?
My lord,
First, Prabhakar Gangadhar
my
Prasad.
lord, he is the member of a Gram Panchayat, my lord. He is a member of Gram Panchayat. Plaintiff number 2, he runs a guest house near the suit property. Plaintiff number 3 claims that his land or his ancestors' land was acquired by the KSRTC in the year 1992 and he has not received compensation, so he is a necessary party. My lord, all the 3 plaintiffs are having 3 different independent individual interests. How can that be called as a community interest? And moreover, my lords, section 290 of Gram Panchayat Act also very clearly states that any premises which is under the possession of the state government or central government, they need not acquire any permission. More so, my lords, I filed application for permission. My lords, under 64, I filed application. My lords, for 60 days, they do not even reply. I began the construction on the 70th day. My lords, it is deemed permission. It did not reply. It did not give me permission within 60 days. The act very clearly says, notwithstanding the fact that it was not necessary on my part to obtain permission in the first place.
Their idea for injunction is allowed.
No, my lords, it was initially dismissed by the trial court. They come before this honorable court in a MFA, my lords. My lords, this honorable court, my
Is
lords,
it MFA file? The order sheet?
I will produce photographs to that effect. I will also produce a photograph, please.
No, yeah, I think you can argue what is a will there basing on the impugn order.
No.
Because,
That's
no, both the,
Writing,
any of the concept, because you understand, no, we are not looking at what all the new contention that's going to be put forth before this court. Even those photographs, looking at the impugned order and how the suit is filed, how can it be maintained? How can there be an injunction in this nature?
I'll satisfy.
Yes.
Kindly pass out in that case.
Tomorrow I'll take up this matter.
I have family function tomorrow, I have a family function tomorrow. That is why I requested for 19th.
On reopening day, the matter may be ready.
With respect to that one submission, my lord, now those beings.
You understand, we are at, your matter is 25.
Please.
It is 12:22.
Please.
Court will complete the work in next 10 minutes.
Please.
So the court can't wait till 2:30 for you. I have other work to do.
My lords, no, my lord. My only submission, my lord, if on reopening day, if they are stating, my lords, now I have built, my lord, those beams which weigh around 200 kgs, I have produced photographs, my lords. They are temporarily welded. The 100% of the, up to 80% of the proposed height are already constructed. My lords, they are temporarily welded because once the structure reaches 100%, that is when they finally do the permanent welding. My lords, if those beams were to fall, my lord, it is in the bus stand. The public are traversing through the under construction property. Photos may be seen for a moment, my lords. Those beams weigh around 200 kgs, my lords. It is a temporary structure. They are temporarily welded to take into consideration of the heat as well as the winds, my lord. Subsequently, they will be fastened with the bolts. Now, up to 80% of the work is complete. Then they file institute to suit. I began my construction in the month of June 2024. They file a suit in August of 2024. After 2 months, they file. That is on the same ground. The trial court stating that the balance of convenience was in my favor. Dismissed their I, my lords. Now, if those beams were to fall, and if any passerby or any person who was traversing through this.
By this order, you are restrained from.
Please, I am restrained from constructing.
I had the benefit of expert interim order for a few days. After hearing, my application came to be dismissed. Even though it was held by the trial court, that I got prima facie case in my favor.
What is the
only
prima facie case in your favor?
First of all, is without permission is making construction. He is not a government. Section 290 will not come to his benefit.
If he is not making a construction without a permission, then who is authority to take action against him?
The local authorities have given notice to him. Local authorities have given notice to him.
Then they will proceed.
I am not responsible and the corporation. On my premises, not building is constructed. I was the one who had bought on the tender and he was the X1, they could not know about it. He is the landlord to the government because it's a transport corporation. Government article of the constitution. That's safe. Therefore, the laws, as per the we did not seek permission. No government building or construct permission to the other. But it is our duty to not that we take care of all the local bylaws and regulate our tender constructibility. Therefore, the laws, he has not applied. I think my friend was wrong. He has not applied. It is correct. He cannot apply. I have the owner of the property.
Yes, please on record. He has applied the.
Even if he has applied lots of places, because he cannot have the owner of the property. Yes. On my land, not the building is coming on. And I am the same.
What I am seeking is only.
And lots just lots of complete my facts. I will not just add to what you understand. These three persons got the opportunity for prayer the Lord in the guise of injunction, what they are asking for is relief of cancelling the tender.
Which they can't do. They have nothing to do with the tender. And what is the right of a private party to say declare a tender as?
My contention is my grievance is not regarding tender. The purpose for it.
No, whatever is your grievance speaks through your relief.
No, my only concern is not regarding not a tender.
First of all, as it is framed, the relief that you are seeking, can it be granted?
Kindly give one short accommodation. I'm only seeking. The first time matter has come up. Kindly let me take instructions.
It is for the public interest.
Yes.
Some private parties approaching the court can't have this kind of a relief. Maybe your interest is affected still. That is in the larger public interest. Why it should be stalled?
No, if the construction is made, then it becomes
clock cannot be set
How
back.
how do you stop them from making the construction is the first question.
Yes. I'll answer, my lord, I'll satisfy the court. About 4 days back, vacating application was filed, I'll take instructions and file objections. I'm only seeking short accommodation, my lord. Nothing will happen if the matter is heard on reopening.
My lord, if the beams are to fall.
It's a long time. Holidays or
2 weeks,
court
my lord.
opens
It's
on
only 2 weeks.
sixth.
And that
Let the construction go on, then
No,
subject to the result of the.
Kindly pass on, my lord, I'll come back. I've not read the file.
Even because Section 21 of PPP Act, my lord. For a moment, that will clear all the doubts of the honorable court. Section 21 for a moment, my
In
lord.
the chamber, Sector 30.
Please, ma'am.
Yes, next. Yes, next. Yes.
Number 26.
Husband petition. The wife filed a criminal misdemeanors for maintenance loss. The trial court awarded 30,000 per month. But the
Trial court awarded 5,000 or 6,000? How much is awarded?
30,000.
30,000,
But the first of all, before the marriage, the respondent has presented yours to the evidence that
Is there an interim order?
No, this is the first time this.
It's coming. Yes. No, interim order, you can't say anything now at this stage. How much is the amount granted by the court? 30,000. What is your income?
6 is the driver my loss.
How much is earning?
6,000.
How a driver is granted where? Which driver is working for 6,000? Wherever he works, 6,000 a driver, nobody is ready to drive a vehicle for 6,000.
And even he don't have any assets or he is residing in brother's house.
Let's see the order. Basing on what basis the court has granted?
She's also stated that he is doing a business real estate.
No, but where is the evidence? There must have been some evidence.
Page number 42, para number 16.
Read.
She's not able to produce any document to show that he is having that much earning loss.
He is having a loan to a tune of rupees 9.5 lakhs and he is paying EMI of rupees so and so.
We have not produced all the statement of accounts of his bank, who banks statement.
My loss, kindly see the ultrasound report, my loss. It is the evidence to show that she is the.
No, yes, replace the bank statement. Where is the material for the court to come to such conclusion that he can pay 30,000? Let him say.
We are stating that he is a businessman.
You cannot, it's not about stating. There should be some material before the court. You can say 101 things. 30,000 is a big amount towards maintenance. At least his salary should be something around 90,000 or 90,000 must be done.
My lord, intentionally is hiding his statement of accounts. And only first page he has produced, my lord.
Then court should have insisted that how did you do it? Produce everything. Not like that. 30,000 is on the higher side. How much is ready to pay?
Even as per the ultrasound.
You have to pay. What is that he is ready to pay? Then both of you can come up with the statement of assets and liabilities. On that, stay will be granted. Or if you're not coming out with that, then I'll adjourn it to file your statement of assets and liabilities. Then we'll see. Both the. Two, what? You're not able to take a decision? Tomorrow I'll call. Then you think and tell. Tomorrow, yes.
Number 27. Is it Jana for me?
Petitioner really challenged the ex-party maintenance order by the.
How much is granted?
2,000 to the child and 7,500 to the wife.
7,000.
Please, ma'am.
9,000 altogether.
Total 9,000. My lord, the ex-party ex-party.
What is your income?
Earlier he was working at Muscat, my lord. Now he left his job and decided that his parents announced that.
What is his age?
Age you are also 40 years.
Why he left the job? Why is he not working?
My lord, due to the COVID-19, he left his job and he came to India.
and requested the respondent to recite.
We'll hear all these things once the respondent enters appearance. What is that you are ready to pay now?
No, there is 50%, but moreover, the entire.
6,000 on 6,000 state. They shall, the land council the petition submits it's an ex parte order. Petition is not working. And the amount of 9,000 that's granted with the court is on the higher side. Considering the submission, they shall be stay for further proceedings. On the condition that the petition shall continue to pay an amount of ₹6,000 by 5th of every succeeding month. And the arrears at 6,000 within 8 months, 8 weeks from the date of receipt of the copy. Default order, notice to the respondents. Yes. Mrs. Smarter on February 11th. Yes, next.
Good morning.
For petition from Bangalore to Hubli. Reverse petition pending before the.
Which year is the MC?
2000.
Filed by the husband. Wife is residing in?
Hubli.
Land counsel for the present petition is filed seeking transfer of the divorce case filed by the husband on the file of the family court at Bangalore to Hubli. It is stated that the distance between both the places is 400 kilometers and it's difficult for the wife to travel. Considering the same, they shall be stay of all further proceedings in so and so till the next date of hearing. Petition is permitted to take out notice, hand summons on the counsel appearing with the respondent and file a memo to that effect by Mrs. Martin on 11th of February. And by the time if the memo is not filed, the stay granted by this court stands vacated.
Along with the emergency notice to be.
Registry is also directed to issue emergency notice. Next.
Rodriguez.
Where?
From Yellapur, Karnataka to Bengaluru. Admittedly, both the parties, husband and wife, they are residing in Bangalore. During the filing of reverse proceedings. The reverse proceedings was filed by the wife. And the husband is made to run around from Bangalore to Yellapur.
What is the material to show that the wife is residing in Bangalore?
Please may kindly come to annexure C, page number 32 of the petition. This is the divorce petition which is filed by the wife. May kindly see the past writing now decided.
Court of Yellapur, President of Prashant Kotana Post, Delhi, Yellapur Taluka District, Uttar Kannada.
Now residing at house number 485 cross Vinayak Nagar, Atta Post, Bangalore.
Then counsel for the petitioner submits that even as per the cause cited, the wife, though shown the address of the parents at Yellapur at Delhi, Yellapur Taluk, but it is stated that the residing at house number 415, 5th Cross, Vinayak Nagar, Bangalore. It is submitted that the husband is residing in Bangalore. Both the wife and husband are residing at Bangalore. Only to harass the husband, the petition is filed at Yellapur. Considering the submissions, they shall be stay of all further proceedings in MC number 34 of 2024 on the file of so-and-so. The counsel for the petition is permitted to take out hand summons to the counsel appearing to the respondent and file a memo to that effect by February 12th. List this matter on 13th. By the time the memo is not filed, the stay granted by this court stands vacated without further reference to the court. Issue emergent notice to the, in addition, issue emergent notice to the respondent. Yes. Yes. Distance. Distance.
150 kilometers.
MC is of which year?
2022.
Then what happened between 22 to now?
Now the matter is posted for and wife is living in Vijaypur, serving in Vijaypur, in maternity department. And she is having child also. 4 years child also.
What was she doing without waiting from 22 to now? No, I understand. What is she doing from 22 to now without even moving a petition?
My lord, earlier we have filed for restriction of control rights. That has been allowed.
Where you filed?
2018. And that has been allowed. Against that also we have filed MSA. That is pending before this honorable court.
Now the husband has again filed
now they have filed divorce petition.
Not now, 22.
22, yes, 21.
What were you doing from 22 to now without moving a petition for transfer?
Earlier she was working in Koppala.
Where is this case filed?
It is in Koppala.
She was working in Koppala.
No, no, now he is working in Vijaypur. Earlier he was in Koppala.
Till what time?
2022, my lord, she was working in Koppala.
When did she transfer to Vijaypura?
I don't know exact date, my lord.
Get instruction, that is more important.
Right,
Tomorrow next.
Tomorrow. 28. Number 30. 31.
Yes.
Yes, from Haveli to Huvina, Padagal. Distance is 130 kilometers.
What is, when is the MC?
Please.
Which year is the MC?
2024.
24.
Yes. And also, respondent is facing 2 cases at.
It is submitted that
Huvina.
the husband had filed the MC at Haveri, and she's seeking and she's residing in Vijayanagar.
Yes. Huvina, Padagali Taluk, at district Vijayanagar.
At Huvina, Hadagali, Vijayanagar district. The distance between both the places is 130 kilometers, and it is submitted that there are 2 more cases pending at the place where the wife is residing. Considering all this, there shall be stay of all further proceedings in MC number so and so. Same hand summons, and this is matter on February 13th. By February 12th, the memo shall be filed, or else the stay granted by this court stands vacated. The registry shall issue a merchant notice.
Yes, madam.
Next.
Email number 32.
Yes, sir, the announcement of the.
Just let it go after it. This is matter on 12th of February. Yes, 33.
Yesterday's matter argued, MC petition is filed under 13B, and in the pleadings, specialist pleaded that wife is having custody of the child and she will take care and responsibility of the child. And MC petition is allowed, but.
Oh, yesterday's matter. File your wakalat.
Please, along with affidavit also.
Yes. The petitioner is agreed with the order passed in. Where is that order page number?
39. 39.
Agreed with the order passed by the court on an application under 152 of CPC dated 3/7/2024. The petitioner husband is before this court. It is the facts, wife is before this court. The facts of the case are the marriage between the parties is dissolved by way of mutual consent divorce. In the mutual consent divorce, there is where is that mutual consent that is filed? That petition is filed.
Please.
Where is that?
Mutual consent divorce is filed.
Where is that? That it is stated that.
Page 15, below. Page 15.
Page 15.
Please. Operative portion, Lord, page 20. Joint petition filed by petitioner under 30B of the Act is hereby annulled. Page 20.
Not that.
Starts from 15.
Yes, it's fine. That they have agreed on a condition that the child is in the custody of the wife, and she is taken full responsibility of the for the child care and maintenance. But in the judgment, the same was not reflected. It is stated that when she filed an application for passport along with the child, but while applying the passport application, the passport authority has raised the issue regarding the custody of the child. Therefore, due to lack of documents, the passport authority have declined to approve the passport in the child's name. Then, after going through the judgment, she came to know that the contention of the custody of the child is not mentioned in the judgment. As such, that made them to come before the court for by filing an application under 152 of CPC. The court had passed an impugned order considering the scope of section 152 and observed that under section 152 speaks about the correction of clerical or arithmetic errors in judgment passed by the court. But the application of the petition number 2 discloses that she wants that one para mentioned in the application is to be added in the judgment. And the said proposed amendment in the judgment do not come under the purview of section 152 of CPC because there is no clerical error passed by the error committed by the court, and accordingly dismiss the petition. On behalf of the husband, counsel so and so appeared. He submits that when they filed the mutual consent divorce petition, in that there is a clause with regard to the custody of the child, and it is agreed between the parties that the custody would be with the mother. When the court has passed an order, by order dated, court passed a judgment and decree, that is judgment dated 3rd December 2021. The said aspect do not find part of the judgment, and the judgment is do not find part of the judgment, and the judgment is silent on that aspect. And the aspect next para, in the same para, both the counsel submits that is the intention of the parties, and in the interest of the child, it is very much necessary that that should be incorporated in the judgment and decree passed by the trial court. Next part. Having heard the counsels on either side, there is some material on record. The parties have entered into a compromise, and basing on the compromise, the judgment and decree dated 3rd December 2021 is passed. In these cases of the mutual consent divorce, and this is also an admitted fact in the petition that is filed seeking a divorce, they have also categorically stated about the custody of the child, which has to be with the mother. Now, for whatsoever reason, that's not reflected in the order. For all practical purposes, unless and until the custody of the child is clarified, like how it is submitted by the mother, it would be difficult for them to proceed in certain matters. The court had only considered the scope of section 152 of CPC. Whatever is the provision that is quoted by the parties, ultimately, that should be the endeavor of the court to do substantial justice to the parties. The procedural law is a handmaid of justice, and when the court had failed to incorporate a particular clause whereby the parties have agreed on the custody of the child, quoting a provision of 152, or the scope of it is not material, in the interest of both parties and giving a quietus to the litigation, this court deems it appropriate to direct the trial court to carry the necessary, to carry the same in the said clause to be incorporated in the order. Accordingly, the CRP, the petition is allowed.
Please come on. The petitioner. Petitioner.
By the petitioners, can you be allowed to set aside the IA?
Not the set aside the IA. The order is set aside.
Please.
The order is set aside, and consequently, IA is allowed.
Please.
Please, my lord. The petitioner.
Yes.
The petitioner has a license in Form CL2, Gangavati, my lords, he made an application for shifting to the new location as per Annexure C, which is unobjectionable in terms of the relevant rules under the Karnataka Excise Act. The road is State Highway Gangavati, page number 19. Annexure D is the road drawing as it existed. My Lord, may kindly see note 19, highway drawing prepared by the department. Now, my Lord, to make my premises objectionable, my Lord, one minister and several other politicians, including Mr. Janardana Reddy, who was in jail for several years for mining related offences, makes a representation to the chief engineer, respondent number 1, who, my Lord, under Annexure G, permits the cutting of the road, highway road in between, to facilitate entry to one hospital. Hospital has not requested for that. So that my shop becomes closer to the hospital and objectionable. This is done at the instance of a rival trader. My Lord, may kindly see page number 23. Order impugned. Karnataka Road Development Corporation Limited, which maintains the state highways. Reference number 1, Shri Iqbal Ansari, former minister. Number 2, Shri Sayyid Ilyas Qadri, chairman, so and so. Number 3, Shri Janardana Reddy, MLA. He was the person, because of him, the Ballari is called as Republic of Ballari by Justice Santosh Hegde. Shri Shivraj Thakkar, Honorable District Minister, so and so, so and so. Based on their letter, the chief engineer permits the cutting of the road. As a result, the proposed shop becomes closer to the hospital, and as a result, it becomes objectionable. My Lord, may kindly see the photograph of the hospital is also recently. My Lord, may kindly see page number 22, Annexure F. Just to make my shop objectionable, the road has been cut. Highway road cannot be cut unless there is a decision at the level of Ministry of Road Transport and Highways.
Now, how does this court exercise discretion for your wine shop when
Please,
that is done for the purpose of a hospital?
Hospital is not, my Lord, applicant for cutting the road also.
So, for the going to the hospital, if that is convenient, if that is taken, why should the court find fault with it?
Going to the hospital, my Lord, there is no difficulty at all, because it is in between. My Lord, may kindly see any highways today. We can reach between Bangalore to Dharwad in 6 hours, which was 12 hours earlier. My Lord, under the Indian Road Congress, which is a scientific literature made for the purpose of highways, everybody's safety and care is taken care of. Here, my Lord, they cut the road not for the hospital. I can understand if the hospital recently opened makes an application. There is no application by the hospital to create a road. If at all, my Lord, please, my Lord.
Let them notice the High Court Government Advocate takes
Interim direction to process my shifting application. I will demonstrate, my Lord. Only my Lord, spare with me for 1 minute.
Can file their
They have to pay money to the government of India for the purpose of road use. I can quote my own 1 minute, my Lord, please to hear. My wife has opened one petrol pump in the highway, for which permission is granted by the Ministry of Road Transport and Highway by collecting the fees for using the highway road for creating an entry to the pump. Here also that should be done. Merely because some of the politicians give letter, the chief engineer cannot make that. Will not be kindly direct interim direction to process my application.
7th of January.
For all these two reliefs, they have to file separate two petitions. One is for
Come up with your objection.
Government advocate, I have paid 2 court fees.
Respondent number 1, the panel council is appealing.
Who?
Panel council is appealing.
What is the name? Respondent number 1, so and so takes notice. For respondent number 2, just find out and tell the court officer. Respondent number 2, so and so is directed to take notice.
Yes. They have to file a separate.
Karnataka Road Development, I think here state government appears. It's a government body.
Only last.
Not of February.
Yes.
Case number 35, Ashwini P. Mandi.
Because
Petitioner, my lords, the respondent is actually the legally wedded wife of the petitioner, and owing to a matrimonial discord, she preferred an MC 116 of 2024 before the family court Dharwad. And pending this, she preferred interim application to amend the main petition, wherein she actually bases her allegations on the petitioner that she has taken multiple sums of money, which runs into crores now. And in the proposed amendment also, she says that the documents which are forged, etc., will be annexed herewith, but on multiple requests also, the respondent has not produced the annexures to either the court or to the petitioner. Based on this, we sought time to file the objections, so that the petition and the proposed amendment were incomplete. And hence, our objections was taken as nil, and the matter was proceeded with, and the IA was allowed, and henceforth, the petitioner, the respondent has carried out the amendment.
will she take out notice?
And interim relief of stay can be granted.
No, any of the holidays are coming. List this matter on 6th of January. Petition is permitted to take out the hand summons on the counsel for the respondent. List on 6th of January.
6th of
Yes.
January. What are the number 96?
That's in this matter. Day before yesterday, my lords, I filed an application seeking for withdrawal of the suit with liberty to file a fresh suit on the same cause of action.
You can come up with your objections to that.
Submit. Liberty cannot be granted.
That's why I asked her to file. You file your objections to that. That cannot be granted. Then we'll see. The respondent plaintiff wants to withdraw the suit and filed an application before this court seeking liberty to withdraw and file a fresh suit. Then counsel the petitioner opposes the same and submits that he'll come up with his objections. Delete this matter from the caption part and list this matter on 15th of January. Interim order early granted is extended to that. Next.
Okay.
Yesterday, madam, my lord has asked me whether the deputy commissioner is our authority. It will declare for 5 for subclass 2, madam. And notwithstanding anything containing sub-rule 1 and 2, the deputy commissioner of excise may, with a view to secure convenience, morality, tranquility, decency, or safety of the public, or for any other reason, reject the petition of person. He has an authority. He can.
Yes.
Moreover, school authority has made an application to the deputy commissioner and the tahsildar also, and the social parties also, social persons. They have also made an application to the deputy commissioner and the chief minister also, and to the tahsildar. School authorities have specifically given a representation to the deputy commissioner.
Yes.
But as per the endorsement, which is at Annex D, it states that the shop is situated within the objectionable place, limits of objectionable place. The school, as per their own report, it is situated within a distance of 350 meters.
Let us accept that it is not within the prohibitory distance.
Yes.
Beyond it. It
Yes.
is beyond that.
Yes.
Then the question is, if it is causing any kind of nuisance, whether the deputy commissioner has the power or not. Yesterday you also accepted that such a power is there, but your contention is that no complaints are given by the affected parties, but for the rival claimants or rival parties it is given.
Yes, yes.
For that his submission is, the school authorities have...
There are two objections which are raised by one is school authorities and one by social organization.
Let's forget about it.
Yes.
Let's look at the school
authority. But as far as the school authorities is concerned, they state that some of the people are throwing the bottles within their premises. So if somebody is throwing the bottles in their premises, whether they have purchased the bottles from my premises, whether with an intention to demoralize my...
Where from anybody will get bottles from somewhere and throw in their premises?
My shop is an outlet retail shop, where nobody is allowed to drink wines and alcohols in my shop. only outlet I have to, even the retail shop management, I have to sell the.
No, in
There
that
somebody
case,
takes it away.
in that case, no, it's not a bar.
It is not a bar.
It's an
it is a
outlet.
wine shop.
Wine shop. They will buy and go away. What they will buy? Why will anybody drink on the road?
No, wine shop, they are providing drinking there. It's no, absolutely not. Absolutely not.
Permission should be.
Absolutely not.
Mr. Counsel, there
Please.
should be a permission.
Please,
Whether there is a permission, tell the court.
please, I will get it. Because
Mrs. Mata, application on 3rd of February, delete from the caption parted. Parted. It is not in parted. Delete. Mrs. Mata on 13th of January, interim order earlier granted is extended to that. Yes, 38.
38. Number 38.
it is interim order signed by the petition.
What is interim order?
On Learned Trial Court has 25,000 has made attendance.
25,000 has granted
Yes,
to the wife.
to the wife, along with all
Wife and 3 children.
Wife and
no, at the
children.
time of 2 children, recently 1 more child was born.
At the time of passing order, the 3rd child was born.
So it is how much? Then 10 to the wife, 5,000
5 is to
to
the 3 children.
3 children. What is the income of the husband?
According to 33,000 to 80.
33,000.
To 80.
And in that, if court grants 25,000,
Yes.
and then what about him? There are how many now? 3 plus 1, 4. Last time you only said 15,000.
This is a matter my lord can recollect.
No, he
Earlier-
said something like we calculate.
Not that. He said divide it by 5 and grant it. I said I am very readily agreeable.
I expect to section for this already this honorable court has given direction for the 15,000 to the respondent till today I am paying. As per this honorable court.
Interim order was granted.
Then we'll make it up to you.
No, my lords, can we recollect my submission? This matter was extensively heard by my lords. The previous counsel fully argued. My lord said we will make it 20,000. Though I was not agreeable, but since my lord said it is reasonable, but I agreed because his salary is not 33,000, it is 38,646 as per annexure E3 page
38,000?
38,646. Of course, he is showing some additional deductions, but he has not spoken a word about it.
38,646.
646. As on June 2023, order was passed in July 2023. Today his salary might be more. Let us not rely on that document. But even if we take June 2023, it was 38,646. So my lord said,
Probably that day the court might have said that in 20,000 4 people have to live, and you will be having 13,646 even admitted by you.
no, 18,000 as per this.
No.
Even as per his document. But I am just more refreshing the memory of my lords. I agreed for 20,000 also, saying that for let the final order be passed by the court. And then he gave NOC and my letter pad is appearing.
Yes. My respect is sufficient because honorable court is back. Except this service certificate. That is an only additional work. That is an respondent.
No, we are taking not 38,000 as submitted by him. I am taking 33,000 as submitted by you.
Please.
If you take 33,000, now there are how many? There are 4 people. You are only 1.
My mother is there. And another important thing, Madam, as per the observation made by the trial court, I am paying the LIC, all the children, whatever they made at the time
How
of.
much you are paying per month?
That document has produced before the honorable trial court.
But you have to tell the court.
Pardon?
You have to tell this court that how much you are paying.
That
It is a yearly amount.
Yes, madam. That
LIC
is the
amount.
And one more thing, Lord, the kindly correct the trial court order. Page number
No,
54.
whatever is order of the court, it all revolves around the figures. You don't have to look at the order unless and until you dispute your relation and your paternity.
No.
That's all not the dispute. Let's not look at the trial court order. Now you tell the court accepting that 33,646 is your income. How are you going to support 4 people, 3 children and wife?
My respective suggestion, whatever this honorable court already order passed, that is much for me. Because
How it is much?
because 15,000 is more for me. 33,000, and in addition to that, I will pay the LIC and FD and other.
Where is that? All the things should be placed before the court. How will the
No,
court
those are
understand?
deductions for already.
Where is
marked.
that? Let's see.
Let my lordship kindly see. It's not in addition to this. It is already included in that.
Where is that?
My lordship kindly service page number 35. 36 is what is he relying on. Those are the series of annexures of salary slips for every month. He is relying on page number 36.
It is not 36, I think.
My lordship kindly take annexure E series. First one is the salary slip for March 2023. Now he is relying on April 2023, next page. Already my lordship kindly say there are deductions, including PWD, middle column. All deductions.
No, it is not. What he is speaking about is,
Yes.
in this 33,082, he is paying some amount towards LIC of the children.
No, that is also meant, that's what I am saying.
Where is that?
The last one in the middle column.
LIC 2,292. Then he says fixed deposits. Fixed deposit for the children. He is paying every month something.
Yes.
No, he has spoken out for keeping a fixed deposit of 1,26,000 rupees.
Where is that?
In the order it is there, but there is no document produced by him. I also got it from the order itself, page number 43.
That is a one-time thing. You won't be contributing it every day for that fixed
And that will
deposit.
be realized when the children are their majority. Now 3 children are managing. One is 9-year-old, one is 7-year-old, and one is 1.5 years infant.
My respective suggestion to this honorable court, madam. I am not denying to pay the amount to the respondent because I am admitted, I am not disputing the reasons. To concern this honorable court, can we see my position also?
What is your position?
And another thing, my lord, the main prayer, the honorable trial court.
No, if this court grants.
No, 30,000 plus 15,000
No,
is the main prayer.
if this court grants 20,000, that is 5,000 each to each of the the respondents, and still you are left with 13,646, rounding about 14,000, as per you, not as per
Yes,
them.
yes.
So what 4 of them are having, 3 of them are having, that's yours, 14,000.
That is one aspect. If I may just add to that, that was as of July 2023. 1.5 years later, today, his take-home salary will be more than what he was earning at that time, with all the increments and other things. He is under a government job. It's not a private job.
My respective secretary, honorable court, my lord, talks are going on in trial court. Just today I get the instruction from the client for settling once for all. Settle the matter once for all.
How will they, what about the matrimonial matters? Anything is
It
pending?
is there. It is transferred from this by this honorable court. He had filed a petition for divorce before the Dharwad court. That is transferred to the court at Bagal court. My maintenance petition and both are pending. If they want to settle, they'll settle there. This can be closed. And in fact, on submission,
Then matter is settle the matter.
on the material basis, it is not open for him to argue. My lords are permitting, I can't say no. His previous counsel has argued, it has
No,
concluded.
it's okay, let's not.
That's
go
why I'm
into
saying, Lord.
those kind of things. Somebody has come, we'll hear him.
That's why I did not even oppose for adjournment also the other day. I said if a new counsel has come, he has got.
Now please, now with all that, the way the court will look at all these matters, that it has to be like neither injustice to the husband nor injustice to the family.
The balance
And
has
we
to be
have to
struck.
balance it. And in that process, no, even if the 20,000 is granted and 14,000 to you, that is equal to 3 persons what we are giving it to the 3 persons. That is your children after all.
I do agree, my lord.
You're not giving to
I'm not
anyone.
disputing.
Even for your wife is also, it's just 5,000. And 3 of them are school-going children.
I do agree. My humble request. Maybe 18,000.
Please stop. Agreed with the orders passed. Where is the include order page number?
Page number 47.
Agreed with the orders passed in criminal miscellaneous number 2 of 2023 dated 13th July 2023. This is a petition in IA number 2.
Family court.
In criminal miscellaneous number 02 of 2023, dated 13 July 2023, the husband is before this court. The wife had filed a petition seeking maintenance of an amount of 60,000 per month and rupees 1 lakh towards the delivery charges. The court, by order impugned, had granted an amount of rupees 25,000, that is 10,000 to the wife and 5,000 to each of the 3 children, and granted an amount of rupees, no amount towards any other thing, litigation expenses or delivery expenses.
No. Delivery expenses was paid for.
The land council, the court, while granting the relief, had considered the gross salary of rupees 65,528 and the net salary of 47,000 and JDM CS recovery for rupees 14 lakh 835. And considering all that, the court had granted the maintenance. Agreed thereby, the husband is before this court. Now, counsel submits that court has failed to consider what is the salary of the petitioner. Court has considered only the salary for 1 month, where there are certain perks. According to him, his take-home salary after deduction is about 33,646, and granting an amount of rupees 25,000 as maintenance is on the higher side. He submits that there is a scope for settlement and the matter may be adjourned so that the parties will work out the possibility of settlement. He further submits that as per the order passed by this court, an amount of rupees 50,000 he is paying the maintenance, and he submits that the interim order may be made absolute. Next, as he is not shying away from the responsibility. Next paragraph. Having the land counsel appearing for the respondent submits that in fact his salary is 38,000 and 38,646, and this is as per 2023. And being a government servant, his salary might have been enhanced by this time. Further, it is submitted that 4 people have to live. The mother has to take care of 3 children, and she has no independent income of her own. Father, and the maintenance that is granted is a reasonable one. It is submitted that the father has failed to take care of the children and the wife, which he has an obligation to maintain. It is submitted that if there is any scope for settlement, it could be worked out before the trial court at any point of time, and orders needs to be passed independently. In this petition, next paragraph, having heard the counsels on either side, there is a material on record. The undisputed facts in this case are the petitioner is working as a government servant, and he has 3 children in the wedlock and a wife to maintain. Court, considering the salary of the petitioner, court had granted 25,000, 10 to the wife and 5,000 each to the children. According to the counsel for the petitioner, his take-home salary is 33,646. According to the respondent wife, counsel for the respondent wife, his salary is 38,646. Looking at the wife and the 3 children and the husband, and looking at that he is a government employee, and he is capable of maintaining the children. Further, the wife is not in a position to maintain her children. Considering all these aspects, this court is of the view that if an amount of rupees, if the amount that is granted by the court, like 25,000, can be reduced to 20,000, and it would reach the ends of justice. Accordingly, this court is passing the following order. The order dated so and so is modified, and the amount of maintenance is reduced from 25,000 to 20,000, that is 5,000 each to all the 4 respondents, and accordingly, the petition is partly allowed. Yes. Signatures.
MSA is the ability number 24. The submission is the take with this to in MSA number friends with the submission, but mistakenly try put advocate take notice. Please change
What
that.
you say? It is not reflected as MFA number.
The MSA number is not.
Give that number and take that and we'll see what is it. When who has taken that? Also see who has taken that dictation. Vidya.
నేను కూడా మళ్ళీ ఆర్డర్ చేస్తాను.